1966 ခုနှစ်မြန်မာနိုင်ငံတရားစီရင်ထုံးစာမျက်နှာနံပါတ်304 ZAKARIAKHAN deceased by his L.R. Mr. Mohamed Khan and two others appellant versus the official liquidator Chief Court Building Rangoon Respondent ဤစီရင်ထုံး audio book ကိုအထက်တန်းရှေ့နေဦးအောင်ခိုင်ဦးအထက်တန်းရှေ့နေဒေါ်ပြည့်ပြည့်ဖြိုးနှင့်တရားလွှတ်တော်ရှေ့နေဦးထိန်လင်းဦးတို့မိသားစုကစီစဉ်ဆောင်ရွက်ပြီးဒေါ်ယူပါစောမင်းမှဖတ်ကြားခြင်းဖြစ်ပါသည် Civil Miscellaneous Appeal before ဦးထွန်းတင် and ဦးသက်ဖေ judges ZAKARIAKHAN deceased by his L.R. Mr. Mohamed Khan and two others appellant versus the official liquidator Chief Court Building Rangoon Respondent Winding up of Company Burma Companies Act Section 235 Inquiry into the conduct and acts of directors surrendered and forfeiture of shares entails reduction of capital can do with the sanction of the Court, commission of acts of misfeasance, assessment of compensation on the loss suffered by the company, neither wrong nor unreasonable, acts of directors do not call for benefits of Section 281 Burma Companies Act. Hell, the acts of the directors involving the surrender and forfeiture of shares entail a permanent reduction of the capital of the company, which can only be done with the sanction of the court under Section 56 of the Burma Companies Act. No provisions were made in the memorandum and articles of association of the company authorizing the directors to accept from any director or member the surrender of his share or part thereof and the acceptance by the directors of the surrender of 10 unpaid shares belonging to Roshandin on 22nd March 1948 is therefore clearly unlawful and invalid. Hell also, the conduct of the directors in making collusive forfeiture was highly reprehensible. It is apparent therefrom that the directors in unlawfully allowing the surrender and making the forfeiture of shares had clearly committed acts of misfeasance within the meaning of Section 235 Burma Companies Act. Hell further, the trial court has based its assessment of compensation on the amount of loss suffered by the company and under such circumstance, it cannot be said that the trial court had exercised the discretion either wrongly or unreasonably. In fact, it has made provisions for fair and equitable realization of compensation in the last paragraph of its judgment. Held further, the appellants in accepting the surrender and ordering forfeiture of certain shares might have acted with the intention of relieving their friends without any dishonest intention, but their acts, which are against the interests of the company and other shareholders, cannot be said to be reasonable so as to entitle the benefits of Section 281. Patiam Vital Monokhi Sankaram Nambia vs. Kottayam Bank by an official liquidator Territory and Others ILR 1946, Madras 507, Re Narendas Lahoridas AIR 1934, Sindhi 39, Re Miraza Ahmed Namazi AIR 1924, Madras 703 at 704, Sam Pramila Devi and Others versus People's Bank of Northern India Limited in liquidation AIR 1938, PC 284, The Pioneer Alkali Work Limited versus Amiruddin Shilbwai Date 1926, ILR 50, Bombay 461, Belwan versus The Ceramic Industry Limited, Chanda, ILR 1950, Nagpur 150, Ramaton Nisa Begum versus Price, ILR 12, Bombay 380, TSPL, Tinapa Chadia and Others versus G. Raja Gopalam, Official Liquidator of Oriental Investment Trust Limited, Madras and Others AIR 1944, Madras 536, Peninsula Locomotive Company Limited versus H. Langham, Reed and Others AIR 1937, Patna 293, refer to Nyinso for the appellants, or for the respondent, Udape Judge, the Burma Publisher Limited, Rangoon, a private limited company, duly incorporated under the Burma Companies Act, was wound up by the late High Court on 4 September 1965, when the official receiver became official liquidator, who moved the land judge of the original site under Section 235 Burma Companies Act to make an inquiry into the conduct and acts of the directors, ZAKARIAKHAN, Roshan Khan and KAK Master, and to compel them to pay Jet 18,500 to the company by way of compensation. Pending inquiry, KAK Master died and action against him was dropped under the authority of Patiam Vitil Monokhi Sangaram Nambiar versus Kottayam Bank by official liquidator, Territory and Others 1, where it was held that proceedings under Section 235 could not be continued against the heirs of a deceased director. Public examination of the directors showed that on 22 March 1948, one of the directors, namely Roshan Din, who had agreed in the memorandum and articles of association of the company to subscribe 30 shares of Jet 500 each, was permitted to take only 20 shares by the directors, who again on 14 May 1950 forfeited certain unpaid shares belonging to 3 of the directors, that is, 10 shares belonging to Roshan Din, 5 to Khan, and 12 to KAK Master, on the ground of their inability to pay. Leonard Judge therefore held that the directors, in allowing the surrender and making the forfeiture of certain shares, which they had no authority to do, committed as of misfeasance and accordingly directed the appellant's director to pay Jet 18,500 to the company inasmuch as the liability of the directors of the company for their acts of misfeasance was joint and several. It is against that order the present appeal has been instituted. It is no longer in dispute that the directors of the publisher Limited Rangoon had on 22nd March 1948 permitted Rushandin to surrender 10 shares by allowing him to take only 20 shares, although he had agreed to subscribe 30 shares in the memorandum and articles of association, and that they had on 14 May 1950 forfeited certain shares belonging to Rushandin, ZAKARIAKHAN, and KAK Master, with the sole object of relieving them of liability. These acts of the directors involving the surrender and forfeiture of shares until a permanent reduction of the capital of the company, which could only be done with the sanction of the court under Section 56 of the Burma Companies Act. No provisions were made in the memorandum and articles of association of the company authorizing the directors to accept from any director or member the surrender of his share or part thereof, and the acceptance by the directors of the surrender of 10 unpaid shares belonging to Rushandin on 22nd March 1948 is therefore clearly unlawful and invalid. In this connection, it would be of interest to refer to the decision in Re Narendas Lahoridas 2, where it was held that there can be no valid surrender of shares that are not fully paid, except where shares are forfeited, as it involves a reduction of capital, and before this can be done, the sanction of the court must be obtained. It has also been observed by Divados Judge in Re Miraza Ahmed Namazi 3 that the principle therefore applicable to cases of surrender is the surrender is good if it amounts to a forfeiture. It is not open to the shareholder to surrender at will his share, especially when he has to meet future costs, and it is not open to a company to accept a surrender of shares unless the act of the company can be brought within the rules relating to forfeiture of shares to hold that a company can, by a resolution of its directors, accept a surrender of shares would be to allow a company to reduce its capital at its pleasure. The memorandum and articles of association do not contain any specific provisions how share can be forfeited, but the articles of association provide that regulations 24 to 28 of Table A in the first schedule of the Burma Companies Act shall apply to the company. These regulations deal with procedure where forfeiture of shares is contemplated. It could not for a moment be pretended that procedure prescribed therein will comply with when certain shares belonging to Rushanti, Habdarkhan and KAK Master were forfeited on 14 May 1950. It is settled law that in the matter of forfeiture of shares, technicalities must be strictly observed, and it is not, as it sometimes up to be forgotten, merely the person whose shares are being forfeited, who is entitled to insist upon strict fulfillment of conditions prescribed for forfeiture. For the forfeiture of shares may result in a permanent reduction of the capital of a company. C. Sam Pramila Devi and others versus People's Bank of Northern India Limited in liquidation for. See also the Pioneer Alkali Work Limited versus Amiruddin Shilbhai Dipji 5 and Belwan versus the Ceramic Industry Limited Chanda C. It must be noted that forfeiture in the present case had been made with the object of absolving the person concerned from liability and not for the benefit of the company. The conduct of the directors in making collusive forfeiture was highly reprehensible. It is apparent therefrom that the directors in unlawfully allowing the surrender and making the forfeiture of shares had clearly committed acts of misfeasance within the meaning of Section 235 Burma Companies Act. Learned advocate for the appellants had rightly considered that the directors were jointly and severally liable for their acts of misfeasance, but he submitted that the words "the court may," appearing in Section 235, invest the trial court with the discretionary power in the exercise of which it should not have made an order to pay the entire amount of loss occasioned by the company as compensation against the directors. However, he has not shown us how the compensation should be calculated in the circumstances of the case. It must be remembered that in matters of discretion, the Court of Appeal ought not and ordinarily does not interfere with the exercise of discretion by the trial court unless it can be shown that the discretion has been exercised in a perverse or arbitrary manner. Thus, it has been held by the Privy Council in Ramatonisa Begum vs. Price 7 that it is against the sound judicial practice for an appellate court to substitute its discretion for that of the court below unless the lower court had acted capriciously or in disregard of legal principle in the exercise of its discretion. In the present case, the trial court has based its assessment of compensation on the amount of loss suffered by the company, and under such circumstances, it cannot be said that the trial court had exercised the discretion either wrongly or unreasonably. In fact, it has even made provisions for fair and equitable realization of compensation in the last paragraph of its judgment. Lastly, it has been argued on behalf of the appellants that the lower courts should have condemned and given them relief under Section 281 Burma Companies Act, it must at once be pointed out that the relief under this section can only be given when the acts complained of are honest as well as reasonable. The appellants in the instant case, in accepting the surrender and ordering forfeiture of certain shares, might have acted with the intention of relieving their friends without any dishonest intention, but their acts, which are against the interests of the company and other shareholders, cannot be said to be reasonable so as to entitle the benefits of Section 281. It has been ruled in DSPL, Tenapa Chadia and others versus G. RANGOON, official liquidator of Oriental Investment Trust Limited, Madras and others 8 that before Section 281 can be invoked, it must be shown that the directors have acted reasonably as well as honestly. See also Peninsula Locomotive Company Limited versus H. Langham Reed and others 9. In the result, the appeal fails and is dismissed with cost advocate fees, Jet 34.